I hereby declare this meeting of the Howell Township Planning Board to be open. Adequate notice having been given pursuant to the New Jersey Open Public Meeting Act in the following manner. First, excuse me, I have the wrong sheet. January 19th, a copy of said notice was mailed to the Star-Ledger and the Tri-Town News. Second, on January 19th, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on January 19th, 2017, said notice was posted in the office of the Planning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits, which are on your right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77.
Please call the roll.
Former Mayor Gatto was excused. Mr. Husser.
Here.
Chief Kudrick, I have not heard from. Mr. Russo.
Here.
Mr. Schneider.
Here.
Mr. Tannenhouse is excused. Mr. Boyle is excused. Mr. Seaman.
Here.
Deputy Mayor Nicastro.
Here.
Mayor Berger is excused. And Chairman Nash.
Here.
You have a quorum.
Thank you.
You're welcome.
We don't have any minutes to approve. I'm sorry. Let's, could please all rise for the Pledge of Allegiance, and after that, if we could have a moment of silence. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Okay. Don't believe we have any minutes for approval.
There are no minutes to approve this evening.
Okay. Correspondence.
Correspondence, we have stuff that was emailed to the members regarding ordinances in other towns, but we have 2 ordinances of our own that need to be commented on tonight. One is Ordinance 018-2, amending Chapter 188, Article 1, Schedule 3, Schedule of Bulk and Dimensional Requirements in the Residential Zones of the Revised General Ordinances of the Township of Howell. I don't know if you want to take them one at a time.
Yeah, sure.
I move that,
Well, does anybody have any comment on the ordinance?
Chairman, I just think these came out of the zoning board yearly review, and they're minor in nature, but it was, Ron, you could correct me if I'm wrong, out of that yearly review from the zoning board?
Yeah, I believe that's correct. And just for people who don't know what that is, the municipal land use law requires that the zoning board put a report together every year to the governing body concerning variances that they've granted or not granted and making recommendations. So sometimes when a zoning board sees certain categories of variances coming before them, consistently, and they're granting the variances consistently, the law prefers zoning by ordinance rather than variance, so they make recommendations to change the requirements in the ordinances. So Deputy Mayor is correct, that was the genesis of this.
And Council, we would need, do we need a resolution?
Well, we do need a resolution, so there's a vote. What you're determining is whether it's substantially consistent with the master plan. And also, if you have any comments you'd like to make to the governing body. But essentially, our task is to determine whether it's substantially consistent with the master plan.
Thank you. Okay,
Mr.
does
Chair.
anybody have any comments?
I have no
Mr.
comment.
Chair,
Yes,
Oh, no comment.
no
sir.
comment?
Yep.
All right, so if there's no comment,
I make a motion that ordinance number 018-2 is consistent with the master plan.
do I have a second?
I'll second.
Eileen, call the roll, please.
Mr. Husser?
Yes.
Mr. Russo?
Yes.
Mr. Schneider?
Yes.
Mr. Seaman?
Yes.
Deputy Mayor Nacastro?
Yes.
Chairman Nash?
Yes.
Motion carries. And the other ordinance is ordinance O-18-3, amending Chapter 188, Article 6, Section 188-39, entitled Abandonment of the Revised General Ordinances of the Township of Howell.
Board members, any comments? Seeing none, I'll ask for a motion.
Make a motion that ordinance number 018-3 is consistent with our master plan.
Have a second on that?
I'll second.
Eileen, call the roll.
Mr. Husser?
Yes.
Mr. Russo?
Yes.
Mr. Schneider?
Yes.
Mr. Seaman?
Yes.
Deputy Mayor Nacastro?
Yes.
And Chairman Nash?
Yes.
Motion carries. Thank you. That's all the correspondence I have.
Okay. We have no resolutions to move on,
No resolutions.
and we have no submission waivers to move on, so we will move on to the first application, which is case number SP 1035, Joseph Wilhelm, preliminary, final, major site plan, bulk variance, and woodlands management. It's an application of Joseph Wilhelm as applicant and Joseph and Zelda Wilhelm as owners seeking preliminary and final major site plan with ancillary bulk variance and woodland management plan, approval to remove all existing site improvements and construct a two-story, 9,256 square foot office building with 19 parking spaces along the front of the building on premises known as Block 78.10, Lot 34.01, 2 Clayton Road. This application was partially heard on August 17, 2017, when it was carried to October 5th, 2017. On October 5th, 2017, this application was carried to October 19th, 2017, with no further notice. After some testimony was placed on the record, this application was carried to December 7th, 2017, with no further notice. On December 7th, 2017, this application was carried to December 21st, 2017, with no further notice. On December 21st, 2017, this application was carried to January 4th, 2018, with no further notice, for scheduling purposes only. On January 4th, 2018, this application was it's repeat. On January 18th, 2018, it was carried to February 1st, 2018, with no further notice. After some additional testimony was placed on the record, on February 1st, 2018, this application was carried to March 1st, 2018, and on March 1st, 2018, this application was carried to March 15th, 2018, with no further notice. And Counselor, I hope we don't carry this anymore, because I can't keep reading that.
So just before we get started, substantively, Mr. Cohen, I'm just going to ask you and Mr. Gazarovski to enter your appearances.
Yes, for the applicant, Todd Cohen, attorney.
Yes, for the objector, John Strevens, Ron Gazarovski.
I'm sorry, what's the objector's name?
John Strevens.
And
Strevens.
Okay, just as we begin the hearing tonight, when we left the last time, Council, I think there were very high hopes that the parties were going to get together and come up with a plan that made everybody reasonably happy or equally unhappy. Mr. Gazarovski's presence tonight tells me perhaps that didn't happen. All right. So, I guess, Mr. Cohen, if you want to tell us, where we are now then?
Well, I believe we were last here on February 1st. We had basically concluded presentations on both sides. There was one remaining issue. The board wanted a visual depiction in a colored rendering showing what we proposed as the four-season buffer after getting recommendations from your certified tree expert. We also submitted a landscape berm display that showed the effect of the cars in the parking lot, or the lack of effect, if you would, with regard to the planting of the berm. That was all submitted the first week of March. Revised review letter was done on March 12th by CME, which there are 1, 2, 3, 4, 5, 6, 7, or 8 comments, 8 or 9 comments about the buffer, all of which the applicant agrees to. And I have Mr. McFarland here in case there's any questions about the buffer from the board.
I just have some questions with regard to, or I just want some confirmations with regard to the revised plans. So we had the two non-compliant conditions that were pre-existing the application. They remain exactly the same, correct?
Correct, lot area.
Okay, and then there were 3 design waivers that were requested. Those 3 design waivers still exist, correct?
Yes.
So that was lighting intensity, the landscaping
Yes.
in between the parking areas, and the waiver of the tree planting waiver, where you're going to make a financial contribution. Those are the only 3 design, or that's the only 3 areas of relief that are being sought in addition to the 2 pre-existing non-compliant conditions.
Correct.
Okay. And then just to recap, you said you would comply with all recommendations contained in the reports of the board's professionals.
Yes, and the new ones are laid out in item 4G through O of the March 12th letter of CME.
So that's your case?
That is our case. Is there a
Counselor, I
question?
just want to ask, we've recently received some correspondence. I don't know if the applicant has got it. Direct your attention first to the Monmouth County Board of Health. It's a memo dated March 15th, 2018. And
It's the same gentleman. I believe that's the same report as we had gotten previously from them.
Okay.
There's standard conditions that any site would have to, I believe they deal with checking for underground oil tanks, the proper disposal and septic system, and things like that, all of which we obviously have to get their approval.
So you will comply with this, no
Yes.
problem? Okay. The second is an email from an officer in our traffic unit, police traffic unit. It's requesting that the location of the I sign with planting bed, there's some concern about that it might be within the sight distance triangles.
As we saw that report, I consulted with our engineer and our traffic expert. It is shown as outside the site triangle easement, but we'll be happy to consult with your traffic expert and your engineer and place it, if it needs to be moved back a couple feet, obviously we'd be happy to do that. But we think it's outside the site triangle.
Okay, so we would make that a condition of the,
If there's an approval, we'd make that a condition.
yes,
Correct.
thank you.
Okay, Mr. Chair, I'd recommend that we open it up to Mr. Gazarovski if he's got any comments or cross-examination or anything else he'd like to say.
Sure.
My recollection is, Ron Gazarovski, my recollection is at the last hearing, we basically had completed the case. I think we even had closing statements by the respective attorneys, and we were coming back this evening for consideration of this landscape plan. My only comment is, and with all due respect to my colleague, Mr. Cucchiaro,
Nothing good ever starts with all due respect. When people say that, they don't think I'm due much respect.
those are
you
your
go ahead.
words, not mine, Mr. Cucchiaro. But I do mean that. I respect Mr. Cucciero's land use abilities. But he's referred to this continually as a pre-existing condition, meaning that the size of this lot, which is undersized, is pre-existing. You know, my experience is that would be more commonly utilized when you have a lot which was once, when created.
That's non-conforming.
Can I finish, please?
You can finish, but I'm telling you, you're mischaracterizing the definitions.
Well, then I'll be corrected at some later time, perhaps. This isn't a situation where we have a lot which was once conforming, and then as a result of perhaps a zone change, it became non-conforming. This is a lot which was once totally conforming. It was in excess, I believe, of 80,000 square feet. The applicant's predecessor in title, at a given point in time, came in for a subdivision and created two lots approximately 40,000 square feet. When he did that, the lot which is before you this evening became non-conforming. Non-conforming when historically it was represented to the zoning board, the best use for this lot would be the residence, which is still on that lot. And my only argument to you is that you can't correct this by simply adding landscaping. This was created by a predecessor in title. He wanted this undersized lot, and now a successor in title is attempting to take advantage of that. And I would suggest to you, it really doesn't matter how much you landscape this, you cannot correct the undersized lot. Thank you.
I would note that I didn't use the word non-conforming, I used the word non-compliant. Non-conforming is a defined word in the municipal land use law, and this is not a non-conforming situation. It didn't become non-conforming by virtue of the zoning board either. Non-conforming is defined as a lot or sometimes a structure which is lawful at the time it is created and subsequently becomes unlawful through the adoption of an ordinance. We had a lot of testimony and a lot of discussion at the prior hearings, and I actually agree with Mr. Gazarovski that this should not be considered a hardship because it was created by the predecessor in title. So when I say non-compliant, it means it doesn't comply with the ordinance, and it didn't comply with the ordinance before this application. Non-compliant and non-conforming are not the same word, and they don't have the same definition. So I don't necessarily agree about or even think it's how we should look at it. We're not correcting something. We're not being asked to correct something. The applicant is asking for variance relief to keep this condition. So it's not a matter of correcting something. And Mr. Gazarovski has his argument that what they've done doesn't satisfy the positive and negative criteria, and you'll certainly be required to adjudicate that. But I do agree with him that it's not a hardship. There was an application before the zoning board. This lot was specifically created because they argued at that time that it was not suitable for residential development, or for commercial development. It was suitable for residential development. So the status of the lot, the condition that it's in, is due solely to the predecessor in title creating that. So I don't think the C1 variance is really available to them, but certainly the C2 variance is that they can certainly argue that they're advancing the goals of planning and they're mitigating any negative impact. But certainly, the fact that the lot looks the way it does is solely because there was an application to the zoning board saying that the use that's being sought right now was not suitable for the site.
Okay, thank you, Counselor. I think it's appropriate at this time that we open it to the public?
Yeah, for comment and questions.
Yes. All right, if there's anyone who wishes to comment or ask questions on this application, please step forward to the podium and state your name and address. Seeing none, I will close the public portion.
So I guess, Mr. Chairman, at this point, unless there's further questions from the board, I think if Mr. Cohen has anything else he wants to sum with, or Mr. Gazarovski, you have anything else you want to say?
My only comment would be is that the client whom I represent purchased his lot as a residential building lot as it was so zoned, and at the time he was aware of the prior resolution which Mr. Fitzgerald referred to. He relied upon that, and now, of course, he's being prejudiced by this application.
And the only thing I would add to that is Mr. Struthers, I believe his name was, testified that he was in fact aware that this property would be HD1 zone after he bought his lot and built his house. He was fully aware of that and testified to it.
Mr. Chair, I would counsel that, I don't know that it's really relevant at all what someone relied upon when they bought the property or what they knew when they bought the property. What is necessary for us is to determine, one, whether this is a better zoning alternative and whether they have advanced the goals of planning in Section 2 of the municipal land use law, and two, whether there's a substantial detriment that's associated with granting the variance. And their knowledge of the history of the site doesn't go to either of those.
Thank you. All right, gentlemen. Do we have a motion on the board here? Yeah, really? Just somebody?
Mr. Chair?
Yes, sir.
Yeah, I don't know whether it would be useful or not. You can make that determination for yourself, but I don't know that we ever heard what would be acceptable, to the neighbor, from the neighbor's perspective, whether there's some kind of design that is acceptable or just it's the current situation or nothing. I don't know if that would be useful in your deliberations or not, but I just put it out there.
That's a valid point. Mr. Cohen, would you have any objection if the owner came up and,
Well, I think Mr. Gazarovski can put it on the record.
You're asking whether my client would find something more acceptable?
Yeah, I mean, is there, with the use that's being proposed, is there something that your client would have wanted to see that's not there? Or is it just that, look, this is suitable for residential, it is residential, and it should stay residential?
Let's assume, just for the sake of argument, that my client would prefer it to be utilized for residential, and then going one step forward and saying, well, I could accept something other than residential, then it would be a less intense commercial use than this one is. This is the size of the building.
Well, no, I understand that, but when you say less intense, what does that mean?
A more modest-sized building that would call for less traffic, would not impose some of the, you've created a big landscaping buffering situation, but you've created that for the purpose of lessening the impact that it has on...
So a smaller
on
building, do you have a size in mind?
No, I don't. And yet, Mr. Cucchiaro, respectfully, we're here to decide this particular case. If Mr.
We are, and you are talking about negative criteria, so I'm wondering whether there's a way to satisfy your client's concerns where the negative criteria might be satisfied.
I'll be very happy to sit down with Mr. Cohen and his client if they wish to look at alternative sizes, alternative uses, which could be commercial in nature, but I don't think it's fair to ask me this evening, when we're getting ready to vote, for my client to redesign what they have before you.
You feel you've been treated unfairly tonight?
Mr. Cucchiaro, respectfully, I don't think any boards that I've been before treat either applicants or objectors unfairly. I recognize the fact that they are citizens serving their community. I don't think I've been treated unfairly. I would never argue that respectfully to this board. I know some of you for perhaps over 30 years. I'm satisfied with the makeup of this board. They'll make a decision. I may not agree with that decision, but that's their decision to make.
All right. Mr. Cohen, I think the board is probably prepared to vote tonight. You heard Mr. Gazarovski. I don't know if you have any interest in sitting down with him or not. It's up to you which way you want to go tonight.
I'd like to proceed as we go to see.
All right. So there you have it, Mr. Chair.
all right, that didn't go anywhere. So, gentlemen, again, I ask, do we have a motion?
I just want to say that Mr. Husser, Mr. Schneider, and Chairman Nash have all certified, so they are all eligible to vote.
I have one question, Mr. Chairman.
Yes, sir.
The buffer, Mr. Cohen, can you, still 30 feet?
It's 30 feet, yeah.
30 feet, okay.
Gentlemen, I'm waiting for somebody here. Ms. Cusser, any desire?
No, Mr. Chair.
Mr. Russo? Okay. Can you zoom it out just a little so that we can see the whole site?
This doesn't show the whole site, I will do that.
Hey, Ron, I have a quick question for you.
Yes.
It was testified that there were no discussions between the parties after the last meeting, correct?
I don't remember, I think there may have been some attempts at discussion. Is that true, Mr. Cohen? Or no?
I know that my client has had direct discussions without the lawyers and the objector, but I don't believe anything came of it.
Okay.
Okay.
Tom? And generally, we got to make a decision one way or the other here. Yeah. Mr. Cuchero, can I make a motion as chair?
Parliamentary procedure, the chair really shouldn't make a motion, but I don't know that it's absolutely prohibited. I mean, like, what I can tell you is somebody has to do something.
That's not completely true either.
What was that?
That's not completely true either. If the board can refuse to vote,
We can just stay
they can just
indefinitely.
simply not make a motion and the matter fails.
At some point, our time to make a decision on the application will expire, and it will be automatically approved if we sit here too long.
All right, I'm going to make a motion to approve the application. Do I have a second? No second?
Well, if there's no second, then that motion, there's no motion.
We waited 5, 10 minutes to make a motion. Can we wait a couple minutes to see if somebody wants a second? I think that's a fair request.
I agree with that. I agree.
Agree with what, Mr. Cohen, or with the motion?
Mr. Cohen, give us a
Okay.
couple minutes, because this is,
Okay.
there's a lot to think about here.
Appreciate that.
Mr. Gazarovski, I have a quick question for you. It's your position that it's residential or nothing, correct?
That's not correct.
Can you explain?
Well, I think that, obviously, every property owner has a right to come before a board and make an application for a variance and/or waivers. We know that right now, this property is in a zone which permits some type of commercial use. However, at one time, it was a conforming lot as far as size goes. And that was reduced, as been pointed out by predecessor in title. Our position is that my client's prepared to recognize a use which is perhaps less than residential, but less intrusive than this is. As we can see, where the building itself is located, it's close to my client's property. We had earlier aerial photographs to show that. And having said that, Mr. Cohn and I speak often. We don't really perhaps address the details of his application, but he's always treated me with respect, and he
Understand.
respects the fact that I'm here representing a client. My
Wait.
client's position is that this particular application, he finds objectionable.
But you agree that the zone is commercial, correct? You would agree?
I've attempted to determine where that zone line is, but it certainly is apparent that the majority of this lot is in a zone right now, which is the HD zone. in
Right,
Howell Township.
right, okay.
Right.
You just don't like the size and the nature, I guess, of the actual building itself? It's a
What
little
I'm saying
big,
is...
in your opinion?
Here's what I'm saying. Under your zoning ordinance, this particular use requires a lot that is 80,000 square feet. This lot is not 80,000 square feet. I think it's roughly 40,000
Right.
square feet. So I think that special consideration has to be given to, number one, the nature of the use and the design and layout, the traffic impact, where the ingress and egress is. And remember,
And it has.
but remember, much of this property surrounding this lot is a residential use. There's a residential use immediately across the street. There's a residential use
But-
right next to it.
I've lived in Howell all my life. I've driven down that road many, many times. I understand the nature of it. It's a unique nature, but to be fair, there are commercial right across the street and down the road. It's surrounded on the front and the side. Just for the record,
But I've also said, and I apologize for interrupting you, but
It's
I've
fine,
also
it's fine.
said that my client is prepared to listen to a more reasonable and less intrusive commercial use on this property. Why do you think the applicant has agreed to mask all of this buffering or attempted buffering adjacent to my client's property?
I think we're well beyond answering the question.
Well, Mr. Cohen, Mr. Gazarovski is asking a question that a board member has. But you asked to extend the time to get a second. The board member agreed, and he has some questions that are going to help inform him as to whether he wants to second that motion or not.
So, I acknowledge the fact that because of the opposition, perhaps, that this applicant is receiving, he's attempting to create a buffer that is going to hide the offensive nature of this use. I mean, that's not a reason for granting an approval that we're going to attempt to turn, a sow's ear into a silk purse. You just can't do it with buffering. Buffering is only one of a part of the problem. The other problems are dealing with setbacks, traffic, ingresses, egresses.
No, we went over that.
Ms. Gazarovski, if I may, at the last meeting of this application, the only discussion was a buffer, and now in the 24th hour, you are saying that now you are willing to sit down with the applicant to decide if there was a less intrusive application. Why would that not have been a discussion prior when you were here at the last meeting?
Okay.
And that was what was discussed amongst the board.
Let me answer that question, okay?
Please.
I'm going to try to answer it to your satisfaction. This applicant is coming in for a variance along with waivers. My client is here because he says, and rightfully so, this particular application is not compliant with your zoning regulations. It's not compliant with the size, it's not compliant with other things as well. We came forward and we had extensive testimony from Mr. Thomas, who was our planner. There was extensive cross-examination of the planners of the applicant as well. I don't believe that during the course of this application, there was discussions concerning a lesser use. What my recollection is at the very end is that the board was not happy or satisfied with the buffering and said to the applicant, well, would you be prepared to increase your buffering? He said he would, and he's come back with this. I don't think we ever once got into this issue of my client being satisfied with a lesser use. He said that he would be, but that was never really a part of the discussion during the application. The applicant never came and said, look, I'm looking for an X thousand square foot building, but if the objector or the neighbor, I really shouldn't use the word objector, he's really the next door neighbor. If he feels that something would be lesser, then we're prepared to do that. You listen to the comment of Mr. Cohn saying that my client and the applicant have met on numerous occasions. You know, sometimes lawyers can really, mess things up. So oftentimes applicants and neighbors will sit down and talk. My understanding is these people have sat down repeatedly. They have not been able to come up with a solution.
I was under the assumption, I agree with the deputy mayor here, that the remedy was buffer. We were thinking about the buffer, 50 feet versus 30 feet, maybe something in the middle, maybe adding some landscaping or whatever, which they've done. So I limited, I was really focusing on the buffer the entire time,
I never said, my client never said that this will be resolved by buffering.
It was a good faith attempt to meet in the middle, in my opinion, to the board.
The applicant hasn't moved the building back, he's just simply increased the plantings.
Mr. Chairman, I'm going to second your motion.
Just before there's a vote on the motion, I just want to comment just on that colloquy. So I think it's important to keep in mind, first and foremost, that the burden of proof here is exclusively upon the applicant. So Mr. Gazarovski and his client weren't required to come here and prove anything. The applicant was required to prove something. However, in trying to understand and quantify the negative criteria, I think it's very relevant to understand what the neighbor's issues are with the application. I think that helps us to understand whether there's a substantial detriment, and I think it helps the board and the applicant to understand if there is a substantial detriment, how to eliminate, mitigate, or otherwise, remedy it. So I think it's relevant, but at the end of the day, it's still the applicant's responsibility, to satisfy the positive and negative criteria. So, yeah.
All right.
This is my final comment
Thank you,
on it.
Counselor. Mr. Schneider did second the motion.
Yes.
So, Eileen, let's call the roll.
Mr. Husser?
Yes.
Mr. Russo?
Yes.
Mr. Schneider?
Yes.
Mr. Seaman?
Yes.
Chairman Nash?
Yes.
Motion carries.
Thank you.
Thank you very much for your time throughout this application.
Our next application is case number SD 2983, John and Helen Tosh. It's a minor subdivision. Application of John and Helen Tosh as applicants and John and Helen Tosh as owners of Lot 3, and Daniel and Donna Buckley as owners of Lot 4, seeking minor subdivision approval to straighten a lot line on premises known as Block 24, Lots 3 and 4, 352 Alexander Avenue, Lot 3, and 122 Larrabee Boulevard, Lot 4.
Ready, Mr. Chairman? Good evening. My name is Jan Woders. I'm a partner with the firm of Bathgate, Wagner, Wolf, and Lakewood. I represent the applicants, John and Helen Tosh. I'm also here on behalf of Daniel and Donna Buckley, who's represented by Jason Mandia, who's in the audience at this point, and they own the other lot that's involved in this. Basically, we have a situation here where these two lots, which are existing, which have existing houses on them, families have been living in them for in excess of 10 years. In one case, Buckley's a lot longer than that. The properties were initially subdivided in 1955. And in 1955, the subdivision lot between the two lots is basically as you see the proposed lot now. That lot remained that way until about 2006. The then owner of Lot 3, which is owned by the Tosches, went for a variance because at that point in time, the property was zoned R2 and the lots were undersized for that zone. So the owner went for a variance to the Board of Adjustment and obtained a variance for an undersized lot, along with a variance for lot frontage and front setbacks. That was in 2006. In 2008, the property was developed. My clients built a house on it, and at the same time, the Buckleys, as I understand it, had purchased their house in 2001 and had been residing in their house. Anyway, after the Tosches had the house built and purchased it, they purchased their house in 2008. They purchased it based on surveys that were shown to them at the time, showing the lot line to be as it is on our proposed subdivision plan. At the same time, or just about at the time of closing, somewhat unbeknownst to them, the title company went to the surveyor and said, no, that's really not the lot line. The lot line is, and it's hard to see on this lot, but it's a sort of an odd shape where a portion of Lot 3, which is the lower lot, actually extends into Lot 4, and a portion of Lot 4 actually extends into Lot 3. We're not sure how that occurred. It wasn't in the doing of the Buckleys, nor was it the doing of the Tosches, and it was not discovered until such time as both parties were in the process of selling their homes, and it was determined through a title search that this rear property anomaly existed, which brings us to why we're here. The parties have applied for a minor subdivision in order to relocate the line back to where it should be, back to the point where the parties thought it was, to the point where the parties built their houses in accordance with where they thought the lot was, built their decks in accordance with where they thought the lot was. And so they've applied for this minor subdivision,
Mr. Wouters?
Yes.
If I could just, I think there's a couple pieces of information that I think are really necessary for the board, that I just, if you might confirm them, I think would be helpful in moving on. One, there are no new lots that are being created. There are 2 lots that exist, 2 lots will exist after this. And what's really happening is there's about 4 square feet of area
Correct.
that's being changed by virtue of this application.
Yeah.
This whole application involves 4 square feet that's being readjusted, and there are no new lots that are being created.
Yeah. We're,
But are we creating any, with the existing structures in place, are we creating any variances?
yes, because of the location of the existing structures, which were built in conformance with the requirements when they were built, there is about a 4 square foot difference in lot size, or a little larger between the two. So we're going to need variances for minimum lot area, because they're both undersized lots for the zone. And by swapping the properties, the 2 property owners are actually in the process of swapping the properties. And when this final subdivision, if it's approved, is finalized, then they'll complete their transaction and exchange deeds, at which point in time, the Lot 3 will go from a 13,100 square foot lot to a 13,104 square foot lot. And Lot 4 will go from a 15,096 square foot lot to a 15,088 square foot lot. It's very, very minor changes. There are also minimum rear setbacks need a minor a variance. So we're actually seeking variances for minimum lot area because the zone calls for 20,000 square feet, the minimum rear setback, and also design waivers for the decks that exist that were built in accordance with the regulations as they thought, as they related to the property lines, and also a waiver that says you can't further reduce lots that are non-conforming, and we are in fact reducing one of the lots slightly from what it was.
4 square feet,
Yeah.
yes.
I can't stress enough that both of these properties, there's nothing new being built. They are the way they are. The structures are there, the decks are there. They've been living there for tens of years, and we're just trying to straighten out a problem which was not the creation of either of the property owners.
If I could ask a couple of questions, there'll be no impact to the services to the house, so there's
None.
no change to that.
No change.
And the other thing is, there appears that the fence that is along what will now be the common property line may encroach between the two properties.
If that in fact is the case, that will be adjusted between the parties.
So it'll be located on one
It'll be
lot.
located on one lot.
Okay, and we had some minor technical comments in our report, specifically page 6, item 8. Does your engineer agree to comply to those?
Yes, we'll comply with all those. Correct? Correct.
Mr. Chairman, if I could, because it's basically a lot line adjustment between them, from a planning perspective, this configuration makes more sense because instead of having a lot line that jogs, we'll have a radial lot line, so making the properties much more rectangular. So given that and given the nature of the application, I don't have anything further at this time.
Thank you. You had raised one question, and that is, how are we going to memorialize this, by deed or by a map? The parties are exchanging deeds, but I would suggest that I think we'd be comfortable with a map, so,
I would prefer a map.
yeah. So we'll prepare a map to be finalized in conjunction with the filing of the deeds.
Thank you.
This is a pretty straightforward application, gentlemen, all right? Does anybody, I don't want to have the lawyer be the expert on the testimony here, but this is straightforward, all right? I don't know if we need to put, I'm assuming that's your engineer there.
Yes, this is Martin, engineer from New Lines, but
Well, I think, let's just swear him in. If anyone has any, let's let him agree with what's been stated, and if anybody has any questions. Do you swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth? Please state and spell your name for the record.
My name's Richard Oberman, O-B-E-R-M-A-N, and I'm a professional engineer and planner in the state of New Jersey, working for New Lines Engineering in Lakewood, New Jersey.
You're a licensed professional engineer
And planner,
and planner, and both of your licenses are current?
Yes.
Okay, all right, we'll accept.
And Mr. Oberman, just a quick question. CME has issued a letter with comments on the plans that you prepared, and they bring up a number of issues and changes that they suggest to be made. Are you willing to make those changes? Okay.
Okay, does the, just Counselor, the other party's attorney is here also, all right?
Yes.
I just put on the record that there's no issues with this?
As far as positive or negative criteria goes,
No.
I don't want to
I'm
overstep.
not- no, I'm asking the attorney.
Hi, Jason Mandia on behalf of the Buckleys.
Yeah.
I don't know if you need to swear me in.
No, you just, actually, Mr. Mandy, can you just spell your last name for me?
Mandia. The Buckleys are in full agreement with this application and consent to it, and
Okay, just wanted to have that on the record. Gentlemen, does anyone have questions of the applicant?
No questions.
No questions? I will open it up to public comment. If anyone has any questions or would like to make a statement regarding this application, please step forward to the podium, state your name and address, and be sworn in. Seeing none, I'll close the public portion of this. Any final words that you would like to say, Counselor?
No, Mr. Chairman, thank you very much. Just to follow up with Mr. Mandia, the parties actually have previously entered into a written agreement between them as to the location of this line. They've agreed to this line. They've executed deeds back between each other in anticipation of the line being established, so.
Okay,
Thank you.
thank you. Gentlemen, questions anymore? If not, I'll entertain a motion.
So moved to approve SD 2983.
Thank you. Do I have a second?
A second.
Aline, call the roll, please.
Mr. Husser?
Yes.
Mr. Russo?
Yes.
Mr. Schneider?
Yes.
Mr. Seaman?
Yes.
Deputy Mayor Nacastro?
Yes.
And Chairman Nash.
Yes.
Motion carries.
Thank you very much.
Thank you. Next application is case number SP 805A2-F, MGD Holdings, HOW LLC. It's for a final major site plan. It's an application of MGD Holdings, HOW LLC, as applicant and owner seeking final major site plan approval for a 100-unit age-restricted apartments in 4 buildings, along with associated site improvements, parking, landscaping, and amenities for residents on premises known as Block 25, lots 21.01, 24.04, and 41, 6461 U.S. Highway 9.
Good evening, everyone. Steve Goen, Giordano, Halloran, and
Counsel,
Cecil. I'm
Counsel,
sorry.
Let's just, the
No problem.
board gets secretary.
I'll start over. Steve Goen, Giordano, Halloran, and Cecil on behalf of the applicant. So that was a excellent summary by the chairman of this application. Some of the board members here, I remember from about a year ago, we were here for preliminary approval, and we are back again just for final approval tonight. Back at the January 2017 hearing, when we first introduced this application, some of the board members may remember, this site has a sort of long and unique history in Howell. There was a settlement agreement from about 14 or 15 years ago that related to an affordable housing plan, and this property was, as a result of that settlement agreement, there was a proposed 26-unit single-family development on this site along Maxim Southern Road, and there was a 100-unit age-restricted development, multifamily development proposed at the property along Route 9. As we discussed at the last hearing, the single-family development is now gone. The balance of the property, other than what we are proposing to develop, is going to be deed-restricted and conservation area in favor of the township. So that's a large portion of the property, about 50 to 60 acres that's going to be deed-restricted as conservation area. Our development of the 100 age-restricted multifamily units is going to be concentrated at about a 4-acre portion of the property along Route 9. The balance of the property is wetlands, it's heavily wooded, and it'll be restricted from further development. So one point of clarification is that as a part of our preliminary approval, we did get minor subdivision approval. So the property is currently known as lots 24.05, which is the development lot, where you'll see the multifamily development. That's the portion of the property with frontage along Route 9. So that's now 24.05 in Block 25, and Lot 41.01 in Block 25 is going to be the much larger portion of the property that's going to be deed restricted. As part of our preliminary approval, we received final minor subdivision approval. One of the questions heading into the hearing was about that, the duration of that minor subdivision approval. We have perfected that already, so those lots are currently existing. The property is 2 lots. One will be developed, one will be deed restricted as conservation area. So we did get a review letter from CME. dated March 9th, 2018. I'll just state at the outset that we will comply with all the conditions in that review letter. I have our engineer here, Tony Castillo from SCSI. He can testify to a little bit of the engineering. I know it's been a while since we've been here before. We want to run through what outside agency approvals we've got since we came here the last time, and also give the board a refresher as to exactly what we're proposing here. So, Tony, you can introduce yourself.
You swear or affirm the testimony you're about to give this board is the truth, the whole truth, and nothing but the truth?
I do.
Please state and spell your name for the record.
Anthony, Anthony, last name Castillo, Castillo, professional engineer, state of New Jersey.
Can you give us a little of your educational background and your professional experience, please?
Sure. I have actually testified before this board on a number of occasions previously, but have been significantly involved in the preparation of major site plans for projects such as this, residential, industrial, commercial, in not only New Jersey, but as well New York and Pennsylvania as well.
Okay, and your license in New Jersey is valid at this time?
Yes, it is, sir.
Okay, we'll accept him as a professional expert in engineering.
Okay,
Thank you.
so Tony, why don't you take us, just first, a little background about what we're proposing here.
Sure. Again, good evening. To refresh the board's memory on the project, as originally approved and preliminary approved by this board, our client continues to propose 100 residential units in 4 separate buildings, 4-story buildings, each containing 25
Hold the mic
units.
by your mouth, please.
Car parking will be provided at each of the buildings, both at grade and the inside ground level of each building. We also, as part of the project, a clubhouse and pool are also proposed. In terms of accessing the property, there is a 30-foot wide access road that will provide access to the buildings and also the interior car parking areas that are proposed as well. In terms of stormwater management, as we had previously testified to and received approval for, there are no major changes to the design, which essentially consisted of a number of facilities that accounted for recharge. None of those devices have been modified except for some treatment that had been proposed in a prior application. Those were called jellyfish units. Just so happened that in the weeks after this project had been approved, these units had lost their certification to DEP. In lieu of that, we have put in alternate systems, which are called storm filter units, and those are deemed appropriate by the state of New Jersey, so we propose those. Aside from that, the drainage system has not been modified in any way. One of the items that had been previously requested by this board and was part of the prior approval were berms that were required to be constructed along the southern and northerly property lines. We continue to propose those. In essence, there is a 10-foot high privacy fence that's proposed along both the southern and northerly property lines. From those privacy fences, going inward into the property, there's a 3-to-1 slope. In the southern side, maximum, approximately 2-foot high maximum height of berm. Along the north, there'll be a 4-foot high maximum height of berm, and then likewise proceeding back down at a 3-to-1 slope towards the building units. We've gone over this with the township engineer, provided cross sections, and we've done to the maximum extent possible to address the concern of the board as part of the preliminary approval. In terms of the
Question.
Sure.
Since you were here the last time, we have a ordinance that requires ballards on each parking space perpendicular to the building. Have you taken that into consideration now?
Yes, we have. We have amended our site plan to include those
Okay.
bollards, yes.
I wouldn't say that you amended your site plan, you revised the plan.
Correct.
So each space that faces a structure has one bollard in front of it, correct?
Yes, that's correct.
Okay, thank you.
The other question that the attorney had mentioned before, we have obtained the following additional outside approvals. We have obtained Monmouth County Planning Board approval. We've also obtained the soil erosion sediment control certification. This is all back in 2017. We've also obtained a DOT access permit, and that was back in October of last year. We've also obtained agency approvals for water and sanitary sewer service to the property as well.
Okay, so then the big question, and the reason we're here tonight, just to confirm, we comply with the conditions of the April 20th, 2017 resolution granting preliminary approval,
Yes, we do.
and the plans we're proposing for final approval are substantially consistent with the preliminary approval, correct?
Yes, they are.
So, other than that, if the board or its professionals have any questions for Mr. Castillo?
Any comments?
Mr. Chairman, I do not. I can confirm that the applicant was responsive to the resolution and did comply with the conditions of that. They have agreed to our technical comments. We have nothing further at this time.
Okay, thank you. Deputy Mayor?
Mr. Chair, thank you. I just recall one of the issues we were talking about was the slopes in the front. That was all met, right? There was all the slopes met? All ADA compliant? This is age restricted, I want again, right?
ADA compliant, yes.
Okay, that's all I have.
Any questions from the board? Is this your only witness?
Well, I have our architect and our traffic engineer here as well,
Okay,
if there's
well,
questions, but...
let me just open it up to
Sure, that's
the audience, the public to ask questions. If there's anyone in the audience who would like to ask questions of the engineer, please step forward. Counselor, we have.
And again, this is for questions only. There'll be a portion at the end where you can make any comments you want. So this is just questions of the engineer. Hey, ma'am, if you could just state and spell your name for the record.
Elaine Taylor, Maxim Southard Road. I just have a question. I was wondering if we could get a fence on the back end of the property. My property butts up against it in the back, and I have a farm, and I'm really concerned about any kids or anything that are going to come over and bother the animals, or I don't know. I'm just concerned with liability. I don't want anybody getting hurt, and
There's going to be,
I know you said north and south before, but I
Yeah.
didn't know.
Is your property, Ms. Taylor, where the township property is where it's deed restricted to the township property now?
Yeah, it's adjacent, and it kind of hooks in over there.
Could you show us on the map, please?
I think if I could, it may be best up here. She lives along Maxim Southard Road,
Right.
correct? Do you know your lot number by chance?
2540.
Okay. I'm going to try to help you out here. 2540.
so is this the one down?
Just
So
while,
any of the properties on Maxim Southern Road would front onto the deed restricted area,
Yeah.
correct?
That's
Block
right.
25. Okay, I found her. She's block 25, lot 40.
All
So
right,
she
so-
is immediately south, but it is south of the township portion.
Right, so our property right here, the developable portion
And I
is
think she's
all the
asking
way
here.
over here. So you, from where
My
you are,
concern is this, right here. This is me.
this is going to be a completely wooded area, hundreds and hundreds
It's
of
on-
feet
it's
away.
Could you, could you show us possibly, so we understand what the concern is here?
Yeah, okay, let's see if I have, see, I don't have that. Because I don't have that particular larger view mounted, but what I can say is that from the edge of the property, from her property, it's hundreds of feet away from the edge of the developable portion of our property.
Do you see where it says ARE2?
Yes.
Well, that first section,
Yeah.
right?
I'm just going to go to the site plan. So this is where they're developing? You
Right.
see where I'm circling? And if everybody
That's
looks,
mine
this is
there.
the
That's mine.
homeowner's
All the way
lot.
back.
I'm going to just go to the developed portion, just so you could see how far it is from those limits. So if you look at this map, which is an overall, this is the site, it extends down. This is this homeowner's property. So I would say that the development is probably in excess of 500 feet. I mean, the development's all up here. And then if you look, there's a stream that comes down. This is the residence lot, lot 40 right here.
All right, so you're not, they said north and south. I thought they were fencing in the whole thing, but I just wanted to make sure.
No, just in this disturbed area
Up
along the
front.
buffer.
All right.
So Laura, the section that is to the west of Lot 40, where the stream crosses the lot line, yes, and all of that to the west, that's going to be undeveloped?
Yes, that's all constrained property. You
That's
cannot-
also part of the deed restricted area?
I don't know if that's deed restricted. I mean, it's conserved by way of, there's wetlands there, there's a stream crossing there, so it's conserved by way of the state. This, I think, is the deed restricted.
So what our planning board engineer is representing to you is that the applicant will never be able to come back and say, I want to develop the portion.
I understand that. I'm
Okay.
clear on that. You know, I'm just stating, I just don't want anybody to get hurt, that's all.
Well, do you
Also-
feel comfortable with the fact that?
There is a lot of land there, buffering them. But, if there's kids,
And
kids
also,
can
yeah,
be-
Ms. Taylor, I was going to, on that point, it's age restricted, right?
Yeah.
So-
I'd just like to point out that our development will be fenced in, so you will not have any access from there onto that wetland area.
Oh, okay.
It's gonna be
That's
fenced.
what I needed to
Yeah.
hear. That's what I needed to hear. I'm good now. I'm
I
good now.
thought I was doing a
Okay.
good job pointing and clicking up here.
You're good, you did good. Okay, thank you.
Would anyone else like to ask questions of the engineer? Nope, okay. Counselor?
So, I don't really have anything further from Mr. Castillo. I have our architect here if the board, I don't know that it's necessarily required. The plans are the same as what you saw before, but if you'd like to
Mr. Chair,
take a look at
Yes,
that.
sir.
the board can certainly listen to whoever they want to listen to, but the purpose of final approval is to make sure that the conditions of preliminary approval have been satisfied. I don't think we had any conditions concerning any architectural features, did we, Laura? Yeah, and there was nothing
I would
regarding the
just like to
traffic.
ask the board, Mr. Cuchero, would anyone like to hear any of the architectural testimony? No, the consensus is that we don't need to hear that.
And I would think the same goes for traffic.
Well, I would certainly defer to our board chairman as to whether we've heard enough on traffic.
I'm okay with it, age restricted.
Then I don't really have anything further.
Okay, if that's the case, then let me just officially, I'm going to open this up again to the public. If anyone would like to come up and make a statement on this application, please come forward to the podium and give your name, address, and be sworn in. Seeing none, I will close the public test portion of it. Counselor, if you'd like to summate.
No, thanks.
Okay. Gentlemen, we have a,
Motion to approve, I'm sorry, I don't have my glass. SP 805A2-FMGD Holdings.
do I have a second?
Second.
Who was that, Mr. Husser?
Yes.
Thank you.
Call the roll, please.
Mr. Husser?
Yes.
Mr. Russo?
Yes.
Mr. Schneider?
Yes.
Mr. Seaman?
Yes.
Deputy Mayor Nacastro?
Yes.
Chairman Nash?
Yes.
Motion carries.
Thank you all.
Okay, we have no other applications now. Master plan study?
Yeah, just briefly, Mr. Chairman, we're going to look into the circulation aspect of our master plan at our next meeting a week from today at 7 o'clock in this building.
Okay.
That's all.
You can take
Okay.
Thank you.
I'd just like to ask, or discuss, I think at the second meeting in January, Brian Tannenhouse had brought up about the fact that the professionals might be interested in doing a little training of the board. I don't want to put you guys on the spot here, but has there been any movement on that, any consideration?
We remain interested. So
I'm only out 3 nights a week, so, I mean,
I think the issue was whether it could be done during the week or on a Saturday. Saturday was a little bit of a conflict for some members, if I recall.
Well, I mean, there's certainly, it can be done whenever. We have to notice it, however, because there'll be a quorum of us
I
at the
thought,
meeting.
I thought something like on a night like tonight, when we had a relatively easy agenda, if there wasn't an objection.
I will say this about that. Sometimes when we believe that we have a relatively easy agenda, it turns out anything but. So we can do that, but it's subject to, any kind of bedlam that may,
Could you start it at
spontaneously
5
erupt.
o'clock, so it wouldn't interfere with any applications that start after
Yeah,
7 o'clock?
that we could do, yes.
Can I make another suggestion, because we did this with the zoning board? As the applications, because we haven't had too many new ones, if Laura can correct me on that, right? If we get caught up a little bit, we have dates on the calendar, maybe just one that's, don't schedule anything and have it that night. That's just another option.
What would the board's preference be, to try to slot it a little bit after a meeting, or,
Before a meeting.
well, some
think
of us might have a little problem getting here that early, okay?
I mean, I would like to do it before the meeting if possible, but if, it's up to you guys, whatever the majority thinks. It's easy for me to say, I work down the
Saturday's
street.
definitely out, it's baseball season.
Yeah, I second that, actually.
Before the meetings,
You prefer before?
I would.
All right. Rob?
I mean, I don't want to be the one to say after, but before would be more challenging for me. But that's here.
If you buy dinner, we'll do after, how about that?
No. It's you buy dinner, we're accommodating you. Paul?
As long as it's at the chapter house.
Unfortunately, it's going to have to be here, Paul.
Peter, right?
Could we talk about then, 5 o'clock would be a challenge for me, all right? Could we talk about 5:30, that we would start, and
It's up to you.
say you go an hour and 15 minutes, and then we can take a little small break before we roll into the meeting?
I mean, is this a half-hour presentation, I mean, what are we talking here?
Well, look, if all I do is kind of flick the switch and I can talk all night, that's what my people do. But, what I think, I could speak for as long or as short as you'd like, but what I think, in terms of how long I speak, maybe, we could communicate a little offline as to topics you would prefer me to focus on. That way you get the most out of it, and Laura and Peter to focus on.
I personally, and I guess for our planner, I personally would like more input and guidance as to the various types of negative and positive criteria that we're looking at, and a little more detailed and a little more dumbed down, if you will, explanation. Even though I listen to the planners all the time, kind of like, I tune it out. So if that would be something that you would be interested in?
Yeah, I mean, we could focus on C1, C2,
Yeah.
differences between a variance and a Section 51 design waiver. We throw around things like this. They have different standards of review, all three of them. I think those are good things to understand.
Let me just make a suggestion. When is the classes that are required by the planning board members to take coming up this year?
April 21st.
Mr. Chairman, I would just suggest, because many of you are going to be taking those classes that are required, that you probably do this class afterwards, because I think, from my experience, many of you will have a better understanding of a lot of what MLUL says, and then I believe doing it afterwards, it will stay fresh and reinforced in your minds. So I would think about putting some dates after April.
I think that's a good idea. Although what you'll see in those classes is a very heavy concentration on the 10-question test. that you're gonna be given.
No, they don't, other than Rob, I think everybody here is the expert class.
Yes.
No, I think it's not a matter of expert or not, I mean, it's the
Mandatory.
mandatory
The
class.
mandatory, yeah, I call
yeah.
it the expert, yeah. The
Well, the
non-mandatory
NJPO
doesn't
runs
have-
other types of classes for, like leadership from the chair, advanced, and this is like for the new members to get the get
Right.
certification.
Right. All right, so if we could, can we pick a date that we target so our professionals have something, a date to target for?
Well, if you're looking for after April 21st, you have May 10th, May 17th, June 7th, June 21st.
So let's go for the third Thursday in May.
May 17th?
First and third.
Everybody good for that, for May 17th?
I'm in.
Okay, Eileen, just if we are going to start it early, we'll have to do a notice for that night that we're starting early.
I may not be here that day, but I would have somebody cover for me, so, just to let you know.
For the early portion or?
For either. I have to be in Rhode Island that day, so.
Okay,
Or May 17th.
okay. We'll go with May 17th. Can you, Eileen, can you put out the email to the board members when you post the link?
Yes.
To make it authentic, we can give you a test also.
No, we don't have to do that. That's it. And is there anything else? Anybody has anything else? I'll entertain a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
Okay, thank you.